Good morning, Facebook friends. Look who I got. This is Remington. Sorry for the background noise. My radio show is about to start. This is 30 minutes of free legal advice. I'm Jeff Vastola, your host. I'm a lawyer in Florida, and I am here to give you free Florida legal advice. If you're tuning in outside the state of Florida, enjoy the show. Just keep in mind that my advice is only good in the state of Florida. I have to keep telling people that. And I'm sorry about the background noise. I can't turn it down right now. But before the show starts, we do a sound check and we get the volume just right. So if I start messing with it now, then I'm going to ruin the volume settings. So, show intro. Today we're going to be talking about Florida whistleblower cases. We're going to be talking about how important it is to keep track of your personal injury claim if you have one. Keep in touch with your lawyers and communicate. Really, really important. We'll be talking about nuisance claims in Florida. I had somebody call me after the show. And that's a good number to know.
Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody. Thank you so much for tuning in. Again, 30 minutes of free legal advice. I say again because I've been doing the show intro on Facebook Live for the last minute or so. If you'd like to call into the show, whether you're watching on Facebook or listening on the radio, dial 877-850-8585. Just keep in mind that I'm only licensed to give advice in the state of Florida. You can ask me anything you want. I'll do the research that I have to do if I cannot answer your question. And I'll get back with you the following week with an educated response. If I can answer your question right here and right now, then that's exactly what I'm going to do. Good morning, Mom. Nice to see you. Let me see. So today we're going to be talking about whistleblower cases in the state of Florida. They're called Q-TAM, Q-U-I-T-A-M. I'm not sure what the Latin interpretation of that is, but the common layperson term is a whistleblower claim. We're going to be talking about nuisance claims in the state of Florida. Last week, I had a radio show listener call me on my cell phone after the fact to talk about a situation. And, hey, Uncle Jeff, good morning. And so I thought, well, that would have been a great phone call during the show. Let me talk about that question this morning and fill everybody in on the issue of nuisance and what you can do if you're dealing with a nuisance, at least in the state of Florida. And really, probably the most important topic that I want to touch on this morning is how important it is to stay in touch with your attorney if you have an injury claim, any kind of an injury claim, whether it's personal injury or wrongful death or medical malpractice or product liability, anything like that. It really is very important to communicate with your attorney consistently to find out what's going on with your case. I had a potential client come see me this week, and unfortunately I wasn't able to help her because of the situation that she had gotten herself in with her case. So I'm going to talk about just the general issues involved, not her case specifically, but just the general issues so that this hopefully doesn't happen to anybody else. If you'd like to be a part of the Facebook show, type in your question, and I'll do my best to answer it while I'm here. I may have to get to questions that are typed in after the fact because sometimes it's a little bit difficult for me to keep up with the questions while I'm talking. But let me just, and one last thing I'll be talking about today. My one case from my Florida Law Weekly that caught my attention. It has to do with a minor that went to a trampoline park in Florida and went without his parents' consent. His parents were out of town. This was a 13-year-old and didn't necessarily forge the parent's signature. That's old school. You don't have to forge anything anymore because everything's electronic now. But this was a clever young man who went to the trampoline park with everything that he needed to get through the electronic signatory portions of the forms, the waiver forms. Good morning, Vicky. How are you? So I want to talk about this case because he was effectively able to get through the gatekeepers there at the trampoline park, and then, of course, while he's in there, he gets hurt. So his father files a lawsuit and tries to use the argument to say, well, my son was a minor and he fraudulently executed these waiver forms and you should have known better, trampoline park. You should have had safeguards in place to prevent this from happening. Now, before you start, leaning too heavily on the dad, saying, that's not the way it works, the facts are pretty interesting. So we'll talk about that case in a little bit more detail, assuming I get time. So,
I have Dan in Coral Springs.
Oh, wonderful. All right. You folks just heard Sharina, my board operator, telling me we've got Dan on line one. Let's talk to Dan. Good morning, Dan.
How you doing?
Oh, I'm doing fine, Dan. How are you doing?
I'm doing good. I had an interesting question. I'm trying to do some financial planning, and I was thinking of selling my house to free up the equity so that we can invest it into a retirement fund. And I had a strange thought cross my head about creating a corporation that I could sell the house to, and then let the corporation own the house, and then rent the house back from it. Is that legal?
Well, off the top of my head, what comes to mind immediately is the fact that, a corporation has to have a legitimate business purpose. So now, who's to say that that's not a legitimate business purpose? Off the top of my head, I don't know. People create shell companies all the time. And, the term shell corporation sometimes has a kind of a negative moniker attached to it. They think that it's, part of a shell game or a company that doesn't have a legitimate business purpose, but that's not always the case. You can have a shell corporation as long as it's being used as a legitimate business purpose. So you want to create the corporation to own the home, you want to rent the home, pay the corporation rent, and then the corporation would essentially take the rent money and pay the mortgage. Is that what you're getting at? Hey, good morning, Dodi.
Yes, and also for it to become the basis for a real estate investment business.
Okay. Well, you're getting into stuff.
Start that way, but then.
Right. Well, here, Dan, this is what I'll do. I'll research this issue for you of the setting up of the corporation for that purpose, whether that, what I understand, would be deemed a legitimate business purpose, and then you can go from there with corporate counsel and a financial planner, because you're getting into stuff that's way over my head when you start talking about investments and financial planning and stuff like that. All right.
Well, I appreciate it very much. Thank you.
Okay, Dan. So be listening in next weekend, and if you want to talk to me in the meantime, feel free to call me on my cell phone. Okay.
Thank you.
Thanks, Dan. Appreciate it. Anyone listening or watching, if you'd like to call me anytime, you can use my cell phone. It's 833-VASTOLA. That's 833-827-8652. And that number is forwarded to my cell phone 24/7. So feel free to use it. Good morning, Don. Nice to see you. And Mike Powers, how are you? Nice to see you. So what was I talking about when the phone call came in? I don't think I was even talking about anything. So good morning, Maura. How are you? So whistleblower claims. Let's talk about those, because I've got an agenda going here. So whistleblower claims, they're formerly called key TAM actions in Florida. And the one that I wanted to talk about today is one that's been in the media a little bit, and I find very interesting. And if anybody has any specific knowledge about this happening, then I'd love to talk to you about it. But it's when you basically defraud the government in some sense. And there can be other fact patterns as well. But the one that I wanted to talk about that's been in the media is these allegations that hospitals and providers are designating patients as being COVID patients that may not necessarily be COVID patients, because as part of the CARES Act, the medical providers are getting 20% more than what Medicare would typically pay for a patient if they're designated to be a COVID patient. And so numbers are being thrown around all over the place. But there's not one specific number that a hospital, for example, is being given if somebody's designated as a COVID patient. It depends on the treatment that's rendered. But it's essentially 20% more than what they would typically get. So you can see that there could be some incentive there for somebody that's perhaps lacking morals to whimsically designate people as COVID patients, because then when they submit the billing, they can receive 20% more. And so the numbers that are being thrown around is that because of the 20% increase, for Medicare patients specifically, one patient can increase a hospital's billing by up to $13,000 for just standard treatment. And if they go on a ventilator, then the hospital's reimbursement can be increased up to sometimes $40,000. So there was a state representative up in the Midwest named Scott Jensen who was interviewed back in, I think, April, and made the suggestion that it's never really a good idea to put financial incentives in place in the healthcare industry. And people latched onto that immediately. They said, "Oh, wait a minute. Are you aware of fraud? Are the hospitals defrauding the public?" He backtracked a little bit in subsequent interviews to say, "No, I wasn't suggesting that I have any knowledge of anybody specifically doing that." But then, anecdotally, stories start coming out, and it's pretty interesting. There was a guy named, I don't think they gave the name, of course, for HIPAA reasons, but there was a 38-year-old man in Minnesota whose death was attributed to the coronavirus even though he tested negative. And so there was some investigation into that. And ultimately what Jensen pointed out, Scott Jensen, and what the law basically says is that you don't have to have a COVID-19 positive test in order to designate a patient as being a COVID patient. You can have a presumption with a reasonable degree of medical probability, and that's a very funny standard because that's a standard I'm very familiar with. It's a standard we use in medical malpractice cases all the time. It's the causation standard. You have to be able to prove that in order to win a medical malpractice case. So they're suggesting here to designate somebody as a COVID patient without a positive COVID test result, you have to have a presumption within a reasonable degree of medical probability that that patient was COVID positive. And so what they did was they said, well, yeah, this 38-year-old that died in Minnesota, he didn't have a positive test result, but within a reasonable degree of medical probability, we think that he had COVID. And so that's how they were able to get the supplement, the increase in the treatment that was rendered for him pursuant to the CARES Act. So it's an interesting issue because should it come out that a hospital was designating patients as COVID patients when in reality they were not, then this would be the basis for a key TAM action, a whistleblower action. And what's interesting about it is that you and I, citizens, can bring whistleblower claims. It doesn't have to be the state. Now, what you have to do in Florida procedurally is you have to put the state on notice, specifically the Department of Legal Affairs, which the head of that is the Attorney General in Florida. Hey, Debbie, how are you? So if you were to bring a whistleblower claim, you file it up at the 2nd District, which is Leon County up there in Tallahassee. You file it under seal, which means you don't serve it yet. You send it to the Attorney General, and the Attorney General has 20 days to decide whether the Attorney General wants to take the case and prosecute the case or not. Now, you use the term prosecute even though it's a civil action. If the Attorney General takes the case, because presumably it's a very compelling case worth a lot of money, then you, as the private citizen that initiated the case, you just kind of sit back and ride the coattails of the case until it's over. And when it's over, you get a referral fee of sorts. It's set forth in the statute. It's up to 15%, I believe, if the state takes the case. Now, you may have a meritorious case that the state doesn't want. If after 20 days the Attorney General says we don't want to pursue this, then you have the green light to pursue your own private case. And then, of course, any recovery that you get, you do have to share with the state. You still have to share with the state, even if they've said they don't want to help you. And you could be entitled up to 30% if you do it on your own. So, interesting issue for anybody that's in the know and would be able to specifically prove that patients were being designated as COVID patients when in fact they were not, or at least the hospital would not be able to use its standard of certainty within a reasonable degree of medical probability. That becomes an interesting case. Now, let's switch gears and talk about how important it is to keep on top of your own case. If you have a personal injury case, again, any kind of an injury, a wrongful death claim, product liability claim, medical malpractice claim, whatever it may be, it's really important to stay in touch with your attorney and communicate constantly. But most importantly, in a personal injury claim, where you as the claimant are getting medical treatment and incurring medical bills. So maybe not so much, this may not be so relevant to like a wrongful death claim or something like that, but it's always important to communicate with your attorney, and here's why. So if you've ever watched this show, you know that my topics are created based on what I encounter during the week, typically. And what happened this past week with me is that I had a consultation with a potential client, and she came to see me because she was dissatisfied with the attorney that she had been using. Good morning, Patty. And so she came to the office. We had our masks. We stayed, more than 6 feet apart. But she started talking about things, and the more I learned, the more I realized that this was a car accident. The only insurance available was a very small policy for the other driver. She had no uninsured motorist coverage on her own policy, so of course, I'm going to say this, go get uninsured motorist, especially if you live in the state of Florida. It's super important. And the problem with the case was that nobody was communicating, and she had racked up medical bills equal to the amount of insurance that was available. And you may say at first blush, well, that's not so bad, right? Well, why doesn't the insurance company just pay the claim and then, she can pay her bills? Well, the problem with this particular claim is that very early on, the insurance company had sent a letter saying, we're denying your claim. So, and these were documents that she had with her and she shared with me, and I was able to see them. So she didn't understand what it meant, because I asked her. I said, I could see the date on the letter, and I could see, what date it was this week when we were talking, and this letter was from a long time ago. And I said, did anyone ever explain what this letter meant? And she, of course, no. So the problem was she should have known from the very beginning, from the time that she had incurred only a small amount of medical bills, that the insurance company was denying the claim. They were denying the claim because they were taking the position that the accident was actually her fault and not the fault of the other driver. So what happened was she continued under the assumption that she had a good claim, getting medical treatment that was being recommended by the medical providers, and ended up racking up a huge bill, being treated on what's called a letter of protection, where when you don't have health insurance in the state of Florida and there's no other way to pay a doctor, then you can use a letter of protection, if the doctor will accept it, to get medical treatment. And then the doctor, the medical provider, actually has a lien on the file to be paid from the outcome of the recovery. Now, it's not contingent on a recovery. And that's where a lot of people start to think, oh, well, the lawyers and the doctors are all in cahoots, because, the doctor is only going to get paid if there's a beneficial recovery here. The liens that are established through a letter of protection specifically state that the doctor gets paid from the resolution of the claim, yes, but if the claimant doesn't recover money, that doesn't extinguish the lien. The patient still owes the money to the doctor. So anyway, in this particular case, I had to explain to this potential client that came to see me, who ended up not being a client because there was really nothing I could do, was that unfortunately now she's in a pickle because she's owing all this money. The only way to try to get the insurance company to pay the claim is to file the lawsuit. Hey Patty, good morning, you're welcome. Yes, definitely get as much coverage as you can. The only way to convince the insurance company to change its mind and pay this claim is to file the lawsuit. And so, of course, she asked the question, well, why aren't you willing to file the lawsuit? And I said, well, look at it from my perspective. You've got a very low limits insurance policy. And in order for me to file the lawsuit and get your case to a trial, I am going to spend more money just in expenses, just in my costs, as what you will recover from the insurance company. And my contract of a contingency fee says I only get paid at the end of the case, and I get paid from the proceeds of the recovery. And then in addition to that, I get my costs reimbursed. So I said to her, why would I file a lawsuit if the pot at the end of the rainbow isn't even enough money to reimburse my expenses? There's no money left to pay for my fee, which is what I get paid for the service. It keeps the lights on and pays my employees. It's a no-win situation. And I hate being in that situation. I hate having to tell people that I can't help them. which is why I tell people all the time, get uninsured motorist coverage. It's also called underinsured, depending on the circumstances. Get coverage on your policy, because if this woman had some level of uninsured motorist coverage on her policy, she wouldn't be in this predicament. So, lesson to be learned for everybody is communicate. It's not a situation of I'm mad at my lawyer. That's not what I'm trying to express here. You don't get mad at your lawyer. The message is communicate, and make sure that you're asking the right questions of your lawyer. How much coverage is available? Is the insurance company denying my claim? When we go to trial, how much are your expenses going to be? If you were to ask your lawyer while your claim is pending, how much money am I going to get? Be leery of an answer, because a lawyer that tells you how much money you're going to get from a case while it's still pending and while you're still treating probably hasn't been doing it long enough to tell you, I can't answer that question right now. We can only answer that question when you're done treating, when we know what your futures are going to be and everything else. But that doesn't mean that you're not supposed to have the conversations to say, look, if we settled your case right now for this hypothetical amount of money, then this is what you would potentially net from that recovery. Those are the kind of conversations you should have, because if she had been having these conversations much earlier with whoever it was that was working with her, then she likely would not have racked up all of these medical bills. The treatment is optional to the patient, and whether she wants to get the patient or not is up to her, or get the treatment is up to her. So let me switch gears again, and now we've gone from whistleblower claims to communicating with your lawyer to now talking about nuisance claims. And as I mentioned last week, I had a listener call me after the show and say, well, can you help us out with this situation? I've got a question for you for my daughter. Her daughter lives somewhere where the neighbor is giving her a lot of grief. And surprisingly, I thought this level of grief has risen to the point where there was actually a physical altercation between the neighbors. And I asked her, well, did you call the cops? For a physical altercation, that's where the cops will step in and get involved. Typically, if you're complaining about your neighbor being loud or, leaving their garbage can out more than 2 days or something like that, the cops are going to tell you, look, that's not our problem. We're here to protect and serve, but we're here for criminal issues, not civil issues. So when this particular caller mentioned to me that the relationship between the neighbors had deteriorated to the point that there was physical altercation, I was really surprised that when the cops came out, they didn't do anything. So the cops did come out. I don't know enough about the story to know why they didn't do anything, but the way it was described to me was that the cops kind of played it down to say, well, this is just, a minor disagreement between neighbors. You guys need to work it out. So, everybody has heard those stories about domestic violence. In domestic violence situations where there's violence inside the home, somebody's going to jail. If you've watched Cops long enough to know, they always show up and say, oh, domestic violence, somebody's going to jail. Well, apparently if it's a physical altercation between neighbors, somebody doesn't have to go to jail. So, and that's what happened here. But of course, the caller was concerned because it's her daughter that is dealing with this other person. So I brought up the issue of a nuisance and how a lawsuit can be filed to what we call enjoin the conduct of another person. You enjoin the conduct of another person to stop them from doing something that they're not supposed to be doing, or alternatively, if they're not doing something that they're supposed to do, you can enjoin them to do the thing that they're supposed to do that they're not. And that relief, that remedy that you're seeking is called an injunction. So you can file a nuisance action in the state of Florida, and it's coincidentally, it's kind of similar to the whistleblower claim, where and it's regulated by Florida Statute 60.05. That's where you'll find a nuisance claim statute. But you basically file the lawsuit. You have to give some notice in advance of filing the lawsuit, and then you have to give it over to the state to see if they want to prosecute the claim. And if they don't want to prosecute the claim, then you can proceed with your nuisance claim. But if anybody's dealing with a loud neighbor or somebody that's violating the law, sometimes it's more serious than somebody, violating decibel levels, which is normally what people complain about. You might be living next to a meth house or something like that, and they're actually involved in criminal matters. In those situations, that's obviously a nuisance claim that the state's going to want to take on. But if anybody has any questions about whistleblower claims, if you have any direct evidence of patients being designated as COVID patients when they should not be, that's something I'd like to talk to you about. Communicate with your injury lawyer to make sure that you understand what the potential outcome of your case may be, and start that line of communication very early on. And nuisance claims, if anybody has any questions about nuisance claims, you can call me anytime. I am about to run out of time. Sharina's going to tell me I've got 30 seconds or a minute left, but I wanted to talk about this case very quickly. It's out of the 4th DCA, Broward County. Young man went to a trampoline park, and on the computer at the kiosk was able to input his sister's driver's license number. His sister was of age, with a fake name for his father, and the system cranked out an approval, and so he went up to the counter, got a wristband, went into the trampoline park, and got hurt. And the trampoline park defended the claim at the trial level to say he signed a waiver. He was 13 years old, yes, but he signed a waiver that was supposedly approved by his guardian. Well, the attorney for the injured boy said, well, you should have known better, and they won at the trial level. So the trampoline park, thanks Rena, the trampoline park appealed the case, and the 4th DCA came out with an opinion that reversed the trial court, saying that you can't rely on the infancy, what do they call it? Oh no, 1 minute, I'm running out of time. The infancy defense. You can't rely on the infancy defense if you yourself are guilty of the misdeed. So good morning, Lindsay. It's time for me to go. Thank you all for listening. Please let me know how I can help you. If anybody would like to talk to me privately, dial 833-VASTOLA. That's 833-827-8652. Thank you and have a great weekend. Bye-bye.